Judgment in the appeal, Queen on the application of Lebanon and others, and the Secretary of State for the Home Department.
Lord Carnworth will explain the decision of the court.
As has been said, in July 2012, the immigration rules were amended to establish new entry requirements for non-EEA applicants to join their spouses or civil partners in the United Kingdom. These included a minimum income requirement, or MIR, of at least £18,600 per annum, with additional sums for dependent children, to be satisfied by the sponsoring spouse or civil partner. 4 of the appeals are concerned with the legality of the rules themselves and the instructions given to officers operating them. It is said that they are incompatible with the rights protected by the European Convention on Human Rights and unlawful under common law principles, and that they fail to take account of the Secretary of State's duty under Section 55 of the Borders, Citizenship and Immigration Act 2009 in relation to the welfare of children. The 5th appeal of SS relates to the refusal of entry clearance under the MIR in an individual case. The claims had mixed success in the lower courts, but failed entirely in the Court of Appeal. In this court, in a joint judgment given by Lady Hale and myself, agreed by the other justices, the Supreme Court unanimously allows the appeal of SS, restoring the decision of the upper tribunal in that case. In the other cases, it holds that the MIR is acceptable in principle, but the rules and instructions fail to take proper account of the Section 55 duty in respect of children. The instructions also require amendment to allow consideration of alternative sources of funding when evaluating a claim under Article 8. The reasons in summary are: first, as to the principle of an MIR, the MIR has the legitimate aim of ensuring that the couple do not have recourse to welfare benefits and have sufficient resources to play a full part in British life. The income threshold chosen was rationally connected to that aim. The acceptability and principle of an MIR has been confirmed by the European Court of Human Rights. As to the treatment of children, the rules assert that the Secretary of State's Section 55 duty has been taken into account, but nothing in the relevant section gives direct effect to it, nor do the instructions fill the gap. As to alternative sources of funding, there are restrictions in the rules on taking into account the prospective earnings of the foreign spouse or partner, or guarantees of third-party support when applying the MIR. It is not irrational for the Secretary of State to give priority in the rules to simplicity of operation and ease of verification, but operation of the same restrictive approach outside the rules is inconsistent with the evaluative exercise required by Article 8 of the Convention. The rules or instructions need amendment to reflect this. And finally, as to the individual appeal by SS, in the light of the tribunal's finding that there were insurmountable obstacles to the couple living together in the Democratic Republic of Congo, and having regard to the other circumstances of the case, it would be wrong to interfere with the tribunal's judgment that the extreme interference with family life could not be justified.